Everyone can be seated. Good morning, members of the jury.
Good morning.
Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. State. May it please the court, counsel.
Shortly before 7 o'clock on Thursday, January 27th of 2011, with her husband half a globe away, at a distance from which he was unable to provide immediate protection to his children, this defendant, desperate, depressed, angry, but very determined. This defendant, who was despondent over what she considered the inevitability of divorce and fearful of a life alone, implemented her long-standing plan to take the lives of her children. This wasn't an act of multiple homicides committed with immediacy or urgency. These were deliberate, well-planned, and well-implemented and concealed homicides. Showing you an enlargement, ladies and gentlemen, of what's in evidence is State's Exhibit number 33-0. It is a page of the journal of the defendants. And there is no doubt this is the defendant's handwriting. Remember, her DNA was found on it. Her fingerprints was found on it. Her husband, Parker Schenecker, indicated this is her handwriting. And when I say that she was eager to implement this long-standing plan, excuse me, that's the wrong one, of course. $33J. I was hoping it would be tonight, she wrote. I can't stand waiting for 5 days. 5 days she was thinking about this after she had conceived the idea not to use gas in the car, carbon monoxide, but to take her children's lives with a firearm loaded with hollow point bullets. It was a plan that she took deliberate and extensive steps to implement. It was a plan that started in its execution with a 27-mile drive from their Tampa Palms home all the way to Lock and Load in Oldsmar. Hillsborough County. Why is that such an important factor? This is Florida, ladies and gentlemen. You can get guns at many locations throughout this county and everywhere in the state. But she was desperate and she was determined. On that day, the evidence is showing you, she picked up the gun. In evidence is State's Exhibit number 20. The murder weapon. And you know it's the murder weapon, ladies and gentlemen, because the children's DNA, their blood was on it. Ballistics testing absolutely determined that this gun matched the projectile taken from the body of Kaylee Schenecker and with the fragment found within the van. This gun she picked up at lock and load and decided to stop at the Hard Rock Casino on her way back to see if Lady Luck was still with her. But she knew she had to pick up Kayleigh from school, so she got home in time to do that. Bo had a 7 o'clock soccer practice. This defendant realizes it's the ideal opportunity. Bo will be seatbelted in. His actions, his ability to resist will be limited and restrained. And you don't have to rely upon inferences from the evidence in this regard or my explanation of what the evidence means. She laid it out for us, for you, in detail. A detail that required clarity of thought, clarity of recollection, clarity of reflection as she wrote what she had done in her journal, showing you an enlargement of State's Exhibit 33-0, Thursday. I offed Bo on the way to practice. I offed him. You want to know how heartfelt, what her heartfelt feelings were? It's all in language, ladies and gentlemen. Our use of language. Overruled. Our use of language is very telling. She offed her son. Didn't save her son, she offed him. On the way to practice, he saw the gun and told me to put it back in the purse. He had a healthy fight. If that phrase isn't the best example of an oxymoron, a healthy fight, you'll never see another one. I accidentally shot the window, then shot him. Page 74, please. Corroborated by this photograph and evidence, State's Exhibit number 74, with a bullet hole in the windshield, just as she described. One extra shot through the side of the head, and when we got home, a shot to his mouth, because he became so mouthy, just like Kayleigh's. And you don't have to rely upon her words, her description of the act, because you have in evidence photographs, telling photographs of that close-range gunshot wound that she fired in to Bo Schenecker's head. To the left side of his head, as he was on her right side in the van's front passenger seat. As Dr. Adams indicated to you, this stippling around the gunshot wound indicates close range effect. She wanted to make sure she had that gun close enough to Bo's head. While she's driving, this defendant with tardive dyskinesia, while she's driving, she's able to pull that shot off and inflict that fatal wound. And ladies and gentlemen, when she gets home, one shot in the mouth, his mouth to mouth. Again, at close range. Bo had a healthy fight, she wrote. How do you know that? Do you have to rely upon her words? No, you don't. You have physical evidence in the context of these photographs. Exhibit 78D. Bo Schenecker's left hand showing close range effect from a gunshot wound. He had it up. He's trying to defend himself. He'd already seen the gun. Julie Schenecker, remember, told him it was a toy gun to put him at ease. But apparently Bo wasn't buying it because his hand's up at the time the fatal gunshot wound was fired into his head. '73, please. Drove the van into the garage, telling everyone we're going to New York City. You don't have to rely upon her recollection at that time, even though it's entirely and in detail accurate. Looking at States 4. She did tell everyone they went to New York City, and she did it with these sticky notes. Said that off Bo in the van going to practice, thought he'd be tying his shoes, which tells you she thought about the precise scenario of shooting him in the van before they even got in the van. But he caught me with the gun. Said he'd hit me if I didn't put it in my purse. He was yelling at me. First shot hit the windshield. Second shot was to the side of the head. Next shot was to the mouth. His mouth and mouth. She left Bo, her son, in the van. She entered the house, having fired this weapon 3 times within that van. States 52, please. She climbed these stairs leading to the 2nd floor of her home. States 56, please. She entered the loft where Felix Schenecker was sitting at the computer desk to the right of this picture. The contrast isn't very good as it's shown, but you'll have the actual pictures and evidence. Felix Schenecker, either unaware her mother was there or unconcerned didn't react to her mother's presence. And the evidence has demonstrated to you beyond any doubt that it was this defendant who walked up to her daughter using this firearm and buried a hollow point bullet to the back of her head. And then, for good measure, shot her in her mouth, her mouthy mouth. You don't have to rely upon her description of the events in the journal. You don't have to rely upon what I say. You have in evidence State's Exhibits 79A and B. I'm showing you 79B, which shows you the location, the back of Kaylee Schenecker's head, where her mother had raised a gun, aimed it at her, pulled the trigger, and fired the shot. 79A, showing you the location of the shot to the mouth, to the mouthy mouth. States 58, please. This gunshot wound caused Kaylee Schenecker to bleed profusely. You can see in this photograph the blood pooled and dried on the plastic mat underneath the computer chair, because you remember the body is not found until the following day. And once you have this photograph and others back in the jury room, you'll be able to see that she bled not only on the mat, but alongside the left side of this chair. State 60, please. And this defendant wheeled her daughter in the chair into a room. State 67, please. And left her in a bed, covered up. This is Kaylee Schenecker uncovered. Left her in that bed, intending, hoping that her husband, Parker Schenecker, finds her body. Finds the results of the act that this defendant later described as horrible, the worst thing she'd ever done. Left for Parker Schenecker to see the Saturday massacre committed on a Thursday that this defendant had planned. This is 33I, or an enlargement of 33I, one of the pages in the journal. And I'm under SUN, which I suggest means Sunday, which would have been the day after she purchased the gun at Lock and Load. This defendant wrote, "I just reread these lines, these last few pages. They're incomprehensible. I'm just losing my mind. I did all my duties, then went to buy a gun. I was planning on a Saturday massacre. But have to wait on the background investigate for 3 days. I'll go back to pick up the Smith & Wesson 38 on Thursday." And she did. Thursday was January 27th, the day of the homicide. The overwhelming evidence, including that entry, and the fact that she had planned the murders, and the fact that she had picked up the gun with the intent to kill the children, is overwhelming evidence of planning and premeditation. Returning again to 33J, another portion where she wrote, indicating her intent and plan. I will pick up the gun on Thursday. This was the original plan. The original plan was to kill the children in their beds. I will pick up the gun on Thursday, then get Bo into my want for sleeping and good night. Sleep in my bed, in parentheses. Calyx, she gets it first. Don't know whether I'll first turn on the light, in parentheses, to blind, or just read to the, can't make that word out, me in her bedroom. I'm nervous. If she took too many bullets, I don't want to have to reload bullets for Bo's deals. She has a clarity of thought about taking how many times she has to shoot to commit her act, to kill the children. She doesn't want to reload. If Bo sleeps upstairs, don't know if he'll hear the shots at Calyx. Hopefully he'll sleep in my bedroom, then upstairs. Can't took Bo to be woken up by gunshots. In her mind, as she's thinking several days in advance about how she's going to do it, she's considering how many bullets she's going to have to fire, whether she's going to have to reload, what happens if one kid hears the gunshots that fatally take the lives of the other child. This is the reflection, these are the thought processes that she is capable of going on in her mind despite the mental illness of depression and bipolar that she was going through. The overwhelming evidence, I suggest to you, proves beyond a reasonable doubt that this defendant committed a first-degree premeditated murder. The state of Florida has carried its burden in this case of proving to you beyond and to the exclusion of every reasonable doubt through the entirety of the evidence that this defendant is guilty of first-degree premeditated murder. The defense, by presenting an affirmative defense of insanity, has accepted a burden of proving that at the time of the offense, the defendant was insane at the time of the offense. It is, as you'll hear from the judge, their burden to present clear and convincing evidence to you that this defendant was insane at the time. Because in the state of Florida, all persons are presumed to be sane. And in a few minutes, perhaps shorter than that, I'll sit down and you'll hear from defense counsel. And I anticipate she'll discuss with you the evidence and how it proves to you that this defendant was legally insane at the time of the offense. And I ask you to listen closely to what defense counsel tells you. Not just as a matter of courtesy, but because this is a significant and important decision for you to make. When you are listening in court today and when you are deliberating, think about whether it has been demonstrated to you by clear and convincing evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue, about insanity. And focus on the state of mind of the defendant at the time of the offense, of the two murders. 20 years ago, not 4 years ago before the murders, at the time of the offense. That is the critical time frame for your determination as to whether or not the defendant is legally insane in this case. Because of the way procedures operate in the state of Florida and in these criminal courts, I'll have an additional opportunity to address you, at which time I'll discuss my view of the evidence of the defendant's state of mind at the time of the offense. I thank you for your continued concentration over these last 3 or 4 weeks. We know it's been a long road for you. I ask only you extend the same courtesy of your considered attention to defense counsel when she addresses you once I sit down. Thank you.
May we proceed?
Yes, ma'am. And with that, members of the jury, I'm going to give you what will be a short, about 15-minute comfort break before we turn to the defense. As I send you out, I'm going to remind you that we remain in the course of trial, not to discuss this case among yourselves, not to discuss it with anyone else, not to allow anyone to discuss it with you or in your presence, not to speak at all with attorneys, witnesses, defendant about any subject until your deliberations are finished, not to read or listen to any reports about the case from any source whatsoever, not to do any sort of research, gather information, or communicate about the case, people or places involved, or your jury service through any means, including electronic devices. We'll take about 15 minutes.
All right.
Fifteen minutes.